Good morning, everyone. Welcome to the webinar. I'm Bob Fahy. I'm a partner in the employment team here at VWB, and my colleague Michael Halsey and I are going to be taking you through some tricky issues on redundancies. Can we have the next slide, please? So those of you who are regular attendees may remember that Michael and I hosted the last of our webinars, and we covered a general overview of redundancy consultation processes, and that session was very well attended, and we had a much larger set of questions at the end than we normally do in these employment updates and webinars. So we thought it was well worth digging into a bit more of the detail, so we can try and get you some of the answers that we weren't able to address last time. So we're going to run through selection pools, bumping, suitable alternative employment, reasonable adjustments, maternity and family leave, and age discrimination, and hopefully give you just a bit of practical guidance on how to deal with some of these slightly trickier areas of redundancy consultations. Next slide, please. So our first issue is selection pools, and sometimes the group from which to select employees to be made redundant is quite straightforward and obvious, and not contentious, really. However, there can be circumstances where your selection pool can lead to difficulties and challenges to the fairness of the selection process from the employees who are dismissed as a result. So let's start with some broad principles as I've set out on the slide. So firstly, there are no fixed rules about how a redundancy pool should be defined. It's primarily a matter for the employer to determine, and there's fairly well settled case law to the effect that employers generally have a broad discretion, and tribunals will use a range of reasonable responses test to decide whether it was reasonable to adopt the pool that was adopted. On the final bullet point there on the slide, I've said to use a pool of one, but actually the same test applies to any analysis of the pool. And that means that a tribunal mustn't substitute its own judgment for your judgment. It must analyze whether the approach that you've taken is one that is, as the test says, within the range of reasonable options open to an employer in those circumstances. So a fairly broad discretion, which is generally good news. As well as the practical points on the list, I'll add one other point, which is your choice of pool shouldn't be considered as a standalone issue. It can really help your planning process if you think about the impact of both the size of your selection pool and constitution of your selection pool and the application of your selection criteria together, and consider what impact those two things will have on the outcome. So for instance, sometimes employers, quite a lot of the time actually, employers would like to only consult with the employees who are provisionally selected for redundancy after the selection criteria have been applied, rather than consulting with all of the employees in a pool. And often that's for hopefully obvious purposes of minimizing upset to employee relations. However, it's not without risk. And that risk increases the narrower your pool for selection becomes. So to take that to its sort of logical conclusion, where the choice of the selection criteria has the practical result that selection for redundancy is made by the choice of a pool and criteria, where that makes your decision, then that puts you in a position where you really have to consult about those issues in order to have a fair redundancy. So it shifts the goalpost for you about what the scope of your consultation should cover. So all of these things link into your planning process. As I've said there, a pool of one can potentially be fair, but it's subject to a higher level of scrutiny by the tribunals. And we'll come on to look at pool of one in a bit more detail on the next slide. But that's not to say that too narrow a selection pool is your only risk. So you may think that it would be relatively obvious that you shouldn't group together, for instance, employees with a wide variety of skills from different departments, such as, say, accounts, sales, quality control, and warehouse management, and put them all in the same pool, call it administrative staff, and then select for redundancy from that pool. That's exactly what happened in a case called Contract Bottling and Cave from 2012, where, probably unsurprisingly, the EAT upheld a tribunal's decision that the resulting dismissals were unfair because there was no fairness of application of selection criteria across such a broad and diverse constitution of the workforce. So pool has to be appropriate. Too big can be as much a problem as too narrow in the wrong, I suppose, circumstances. I would say that most of the questions we get about pool size are about having narrower rather than wider pools. So let's go to the next slide and have a look at a pool of one. So a general rule of thumb, if in doubt about the fairness of a pool of one, use a wider pool so that you've got less scrutiny of your decision, because that automatically comes with a narrow pool. Where there is a narrow pool of for selection, the EAT decision in Mogane and Bradford teaching hospitals, which I've mentioned on the first slide, it demonstrates the importance of consultation taking place at a formative stage where an employee can still potentially influence the outcome. That's the really key point, is the narrowness of your pool such that it deprives an employee of an ability to be properly consulted and have an influence on the decision. In Mogane, the sole selection criterion used was that the employee's fixed-term contract ended before that of her colleague, and so the employer put her in a pool of one, and then fatally didn't undertake any consultation prior to that decision. And as there was no consultation, that could have impacted on the decision making process. The Employment Tribunal held it was outside the band of reasonable responses, and the EAT upheld the decision. So I think that's quite a good practical illustration of how too narrow a pool combined with consultation only taking place after the application of criteria led to an outcome that couldn't be affected renders the process unfair. So it's all about balancing your different aspects of consultation. I've also mentioned the recent case, and I apologize for the pronunciation, Tejera and Zyka Restaurant. This isn't specifically a case about a pool of one, but there were some interesting comments by the Employment Appeal Tribunal about the need for consultation in pool of one situations. So Mr. Tejera was employed as, his job title was tandoor chef. And at the time of his employment being terminated, he was one of a team of 10 chefs. And the tribunal made findings that he was not working specifically as a specialty chef. He was a helper in 5 different departments, but he wasn't able to run any of them. He had far shorter service than the other chefs, and he was junior to the only other chef with the title tandoor chef. Result of the pandemic, reduction in the restaurant's work. He was told he was redundant and would be the only chef chosen for redundancy. And again, fatally, he was informed of this without any warning or consultation process at all. And that obviously led to an unfair dismissal finding on procedural grounds. But then in that case, the Employment Tribunal went on to consider what compensation he would be entitled to as a result of the unfair process, applying the classic Polke principles. And it held that on the facts of the case, it was not unreasonable for him to be placed in a pool of one, which inevitably meant that the redundancy would have taken place when it did. And that timing point's important. So it held that even had a fair procedure been followed, there was 100% chance that the redundancy would have occurred. So it reduced his compensation by 100%, resulting in no award. And that decision was appealed to the EAT. And the EAT said, a pool of one does not always mean that a dismissal would have taken place when it did, because you have to account for the time taken to undergo a fair consultation process. And as a result, it's wrong to reduce the award by 100%. But it's also said it was erroneous for the tribunal to have held that the warning and consultation would have made no difference to the dismissal. And even when there's a small pool for redundancy and even a pool of one, an employer still has a duty to carry out a fair redundancy process. And the EAT said this may well have resulted in a larger pool and a wider selection criteria or a different outcome. So you can't take it as read that in a pool of one, a failure to consult isn't going to have any impact. You should assume the opposite, that there is a possibility that consultation and listening to the employee's input may change the employer's approach to the redundancy selection. So the employer lost that case because it just failed to consult, but the EAT's comments about the potential for consultation to have an impact on the pool itself, I think are quite interesting. So let's move on from selection pools to bumping. And bumping is one of those things, Michael and I were talking about this when we were preparing for the webinar. It's one of those things where I remember there's two cases we're going to look at on the next slide. And I remember my employment law lecturer at university in the mid-90s talking about bumping and describing how there's judicial authority for the final bullet point, that in some circumstances it may be unreasonable not to consider bumping, but couldn't really point us to the situation where that would definitely be the case. And all these decades, I'm afraid, later, I think we're in the same situation. It's quite difficult to say, to identify in any particular process a situation where a failure to consider bumping is going to lead to an unfair dismissal finding. And so whilst there is judicial authority for the proposition that it may be unreasonable not to consider bumping in some circumstances, there's very little practical guidance, even in the cases that say this, on where that will apply. I'll try and identify some factors that might move you in that direction. But I think that the best summary of the current position comes from a case that reached the EAT in 2012. The case citation is Samuels and the University of Creative Arts, where the EAT said, I'm just going to quote it for you here, "It is not compulsory for an employer to consider whether it should bump an employee. If an employer takes the route of bumping another employee, it can be very detrimental to employee relations. It is in essence a voluntary procedure." So I think that gives all of us a fair degree of comfort about bumping. I've jumped straight into when it should and should not be applied. I probably should just mention what bumping is. I take it as read that most of the HR advisors on the webinar will know it, but as it says on the side, bumping is the process of moving a potentially redundant employee into another role and dismissing the employee currently performing that role, classically a senior person into a more junior person's role, where the requirement for the senior person's role is the one that has ceased or diminished. And as I say, there is some suggestion that there may be circumstances where failure to consider it would be unreasonable, but generally it's a discretionary process. So if we look at the next slide, please. So these are the two cases I mentioned, and you can see one's from 1980 and another's from 2004. So I guess at university I was only looking at the first one. Thomas Betts Manufacturing and Harding, it was held where it was unfair not to consider bumping when the employer dismissed a fitter whilst retaining another employee to be a packer without considering whether the fitter could have transferred to the packing work. There's not a great deal of explanation as to why that failure to consider bumping rendered the dismissal unfair, but that was the outcome. And then slightly more recently, the Lionel Leventhal case involved a senior editor who was selected for redundancy on the ground that he was the company's most expensive employee, and his dismissal was found to be unfair. And one of the reasons given by the tribunal was that the employer should have considered making more junior employees redundant and offering their job to the senior editor. And on appeal, the EAT found that whether it is unfair to dismiss for redundancy without considering bumping is a matter of fact for the tribunal, and on the facts of the case, the tribunal was entitled to reach that conclusion. And it's in Lionel Leventhal that they said that there may be some circumstances where a failure to consider bumping does render a dismissal unfair, but that's about as far as we get. I don't think that you need to be too concerned about bumping, but if we move to the next slide, in terms of managing the risk, the kind of practical things you can do are consider at the outset whether it will be appropriate and document your rationale. And that's important because the case law says failure to consider is what might render unreasonable. So if you show you've considered and come to a reasonable conclusion, it's going to be very difficult to challenge that. Secondly, consider including the prospect as part of the redundancy consultation, and keep that as a live issue. So take it into account if you start the consultation process based on a provisional selection, and you start getting challenges from more senior employees saying, you're getting rid of me, but I could do that role, for instance. Be alive to that possibility and show that you're taking that into account. And then some of the factors to take into account might include similarities between the two posts, differences in pay, relative lengths of services, and nature of the employee's qualifications. To that, I might add factors that might move you in the direction of considering bumping. Could be, has the senior employee ever actually performed the junior role? Again, what are the differences and similarities in the two roles? Perhaps if there has been a recent promotion from an old role to a more senior status, and that's relatively close in time to the selection process, that might be another factor that suggests that you should consider a bumping situation. But as I say, generally speaking, you have the discretion to decide whether to do it or not, and it's going to be relatively rare to be in a situation where you end up in a Lionel Leventhal or Morgan situation where it actually renders the dismissal unfair, particularly if you've documented your thought process and reacted to what employees say during consultation. Those are the kind of key risk mitigating factors. Next slide, please. And we're moving on to the last of my three topics, suitable alternative employment, which is a very, very broad area. And really, considering suitable alternative employment is fundamental to the fairness of any dismissal for redundancy. So dismissal is likely to be unfair if no reasonable effort is made to identify suitable alternative employment. Reasonable is a key word. So the scope of your search for suitable alternative employment is not limitless. It's not doing everything you can possibly do. You're certainly not obliged to create vacancies where none exists. So, and we do sometimes get this in consultation process where an employee says, well, I could do this role, so create that role for me. And that's not something you're required to do. And when deciding what makes a vacancy suitable alternative employment, suitability is about suitability as to the employment terms, including pay, but not limited to pay, the status of the role within the organization, and very practically the fit with the individual's skills and experience, both them being suitable for the role and the role being suitable for them. In terms of vacancies within groups of companies, again, this is one of those areas where we've had a bit of development over time, and there are older cases where dismissals were held to be unfair for failing to consider alternative employment within groups. And as time has gone on, that the scope of that obligation has become relatively qualified. So an employer will not necessarily be expected to look throughout the whole group for vacancies. A lot will depend on what's reasonable in the circumstances. And the degree of control which one company has over another in a group is something the tribunal will take into account when considering reasonableness, as will the degree of independence of companies within the group. So if there's a shared HR function amongst group companies, that's definitely going to be an indicator towards an obligation to explore vacancies in other companies in the group. If an employer has a significant influence over parent companies or sister companies and fails to exercise that kind of influence to help secure alternative employment, that could well render a dismissal unfair. And in fact, that did happen. There was a case that reached the EAT in 1992 called Eurogard and Rycroft, where it was a subsidiary that had considerable control over the parent and failed to make any effort to exercise it, rendering the dismissal unfair. So there's a scale, there's a sliding scale of reasonableness of the scope of your search amongst group companies. And in some circumstances, if they're all quite autonomous with no shared central functions, you might well have very little obligation. And then there might be, circumstances right at the other end of the scale. I've mentioned trial periods. That could be a whole topic in itself. And obviously there's the statutory trial period process. which is triggered. There's a statutory 4-week trial period, which is triggered if the capacity in place in which the employee is employed and the other terms and conditions of their employment differ wholly or in part from the corresponding terms of the employee's previous employment. So that's a quote from section 138, subsections 2 and 3 of the Employment Rights Act. But the purpose of the trial period, and I'll come back to this in my next slide when I'm talking about practical risk mitigation. The purpose of the trial period is for both the employer and the employee to assess the suitability of the alternative employment for the employee. And in deciding whether the terms of the proposed alternative employment differ, and therefore whether the statutory trial period is triggered, all differences count unless they're trivial or insignificant. Each employment term is considered individually rather than just looking at the overall effect of the contract. And the fact that some new terms may be more favorable than old terms is not relevant. You have to look at the impact of any specific terms. And then in addition to the statutory trial period, you can also agree with employees to essentially contract into either longer trial periods or trial periods with specific parameters to allow you and them to assess the suitability. And the statutory trial period is there for the purpose of preserving the right to a statutory redundancy payment if the employee undertakes a trial period and then rejects the alternative employment. That's slightly outside the scope about what we're talking about today. That's all about unreasonable rejection of a suitable offer of, an offer of suitable alternative employment will remove the right to statutory redundancy pay. And I think we're really concentrating on fairness of dismissal, but it's useful to bear in mind. And then finally, if we just move on to the last of my slides, as I say, I was going to talk about risk mitigation strategies. Probably the bullet points largely speak for themselves. So firstly, and hopefully a bit obviously, undertake a sufficiently thorough search and document your search for alternative employment so that you have a record of the efforts you've made. Bear in mind that the requirement is a reasonable search, not the ends of the earth. Ensure the search for suitable alternative employment is continuous. So carry on searching until the date the employee's termination takes effect. Don't stop when you give notice. Be aware that the obligation to explore alternative employment remains until the termination date. And document your searches and the fact that no alternative employment was found at the time of dismissal. Certainly ensure all potentially redundant employees are told of any vacancies and explain how selection for alternative employment will work. And selection for alternative employment is not subject to the same stringent analysis that selection from a pool is. So you have a relatively broad discretion as to how you go about deciding which employees should receive the offer of suitable alternative employment, subject, of course, to the requirement to act reasonably. And I said I'd come back to this, make appropriate use of trial periods. So if there is a degree of uncertainty about the employee's suitability for the role on your part rather than the role's suitability for the employee, although I suppose that may factor in as well, offer the alternative employment on a trial period basis to give you that opportunity to assess whether they can fit into and properly perform the role being offered. So hopefully those are some useful practical tips around those 3 areas. And now I'll pass over to Michael to pick up on the second set of 3 topics.
Hello, everyone. As Bob says, I'm going to cover the final 3 points, which are around reasonable adjustments, maternity and family leave, and age discrimination. So looking first at reasonable adjustments. Under the Equality Act, the employer has a duty to make reasonable adjustments where it imposes a provision, criteria, or practice, or a PCP, that puts a disabled person at a significant disadvantage in comparison with persons who are not disabled. And a failure to comply with that duty will amount to discrimination. So in a redundancy exercise, generally there are a host of PCPs which are applied, which may give rise to the need to make reasonable adjustments. It's quite a broad-ranging concept in this area. But the classic example in the first bullet point there is using attendance as one of the selection criteria. So tribunals will expect employers to disregard disability-related absence in those circumstances. But there are also probably obligations to make reasonable adjustments which arise with a number of other selection criteria which are commonly used. Some examples will be potentially extending the period of which an individual's performance is assessed, allowing an individual to attend an interview rather than filling out forms around their skills and effectiveness, for example. You might make a reasonable adjustment by changing or omitting certain selection criteria in some cases. Also making changes to the way that competitive interviews or assessments are carried out. It may also be necessary to make adjustments to other elements of the redundancy process. And the second point points to that. So to give some examples of what tribunals have seen as reasonable, postponing a redundancy process where a disabled employee was due to return in the not too distant future, delaying the consultation pending a health assessment, making adjustments to ensure participation in the consultation procedure. So for example, allowing potentially family members to attend meetings or providing suitable alternative notice to meetings for certain people. I think what that both points to is that the facts of any particular redundancy process are really important, and what might be seen as a reasonable adjustment in one case might not be seen as reasonable in another case. It's also important to note that the impact of an adjustment or potential adjustment is quite an important point. So if it's unlikely to have any impact at all, then it's unlikely to be seen as a reasonable adjustment. And the Equality and Human Rights Commission Code of Practice states that whether taking a particular step will be effective in preventing a disadvantage must be taken into account when considering whether it's a reasonable adjustment. Of course, that does raise the difficulty of evidencing to a tribunal that taking the step would have made no difference, because the only way you can show that in most cases is actually taking the step. So if you're going to say that an adjustment would have made no sense, you need to be sure of the evidential basis that you're relying on there. The final bullet point makes the general point that it's not usually considered necessary for reasonable adjustments to create an advantage. So the case of Hilaire and Luton Borough Council is referred to, and that's where the tribunal, or the EAT in that case, found that it wasn't necessary for an disabled employee to be excused from an interview process altogether. There's another case which runs along similar lines, Wade versus Sheffield Hallam University, where it was not seen as reasonable for the employer to have to waive its competitive interview process altogether. However, there are lots of other cases that have made clear that it's nearly always an element of preferential treatment when you're making reasonable adjustments. And it's important to look at the facts in the round in each case. So to look at a famous example of Archibald and Fife Council, which is actually a House of Lords case, so we need to take it very seriously. In that case, there was a duty to make a reasonable adjustment to require the employer to transfer the disabled employee to a vacant post at a slightly higher grade without requiring him or her to undergo a competitive interview. And those two things, the Hilaire and the Sheffield Hallam case and the Archibald case, don't sit that easily together necessarily, but I think they illustrate that it's a difficult area. And the important thing is to look at the facts of the case in the round. So moving on to the next slide. This lists out some areas where we can manage the risks in relation to reasonable adjustments. The first point is to consider and mitigate the risk of disability discrimination in selection criteria. So some examples might be, if you're going to use attendance records check that the accuracy of the information contained and the reasons behind the absence, of course. If you're going to use attendance again as a criteria, think about the period over which attendance was going to be assessed. It might have an unfair impact on some individuals if it's too short a period. If possible, ensure that more than one manager carries out the marking exercise and that the marking is carried out independently. If you're using performance records such as appraisals, ensure that there's sufficient material to carry out a fair assessment. It's also important to reflect, I think, upon whether you're satisfied and you have confidence that the appraisals have been undertaken consistently by different managers over periods of time which are being assessed. And if you're not happy that there are consistent appraisal records or fair appraisal records, is there any other material that can be relied on in addition to those appraisals? The next bullet point is how to communicate with staff and support, communicate with and support at-risk staff who are currently off sick. I think that's a fairly obvious point around allowing written representations potentially and flexibility around consultation meetings. Also, if a member of staff has a psychological condition, is it necessary to provide further guidance and support to that individual during the process? There is a reported case where the tribunal criticised an employer for not providing bespoke support during consultation for someone in that position. Final bullet points include potential reasonable adjustments as a topic for discussion during consultation and demonstrate a meaningful consideration of any suggestions. This is particularly where there's a period of collective consultation with recognised unions or employee representatives. Discussion at that stage of any potential reasonable adjustments can be enormously helpful when it comes to dealing with subsequent individual consultation, if many of those issues have been dealt with and addressed at the collective stage. In respect of individual consultation, obviously you need to ask employees, I think, who have health conditions whether they require any adjustments. And in difficult cases, you might well consider taking some OH advice. So moving on to the next slide. Looking at maternity and family leave, and this slide concentrates on the protection that employees on maternity leave have in respect of suitable alternative employment. So it's one of the standout parts of the discrimination legislation in this country where preferential treatment is required. So if there is a suitable alternative vacancy for an employee who is on maternity leave, they have preferential access to that, to be offered that role over and above individuals who are not on maternity leave, who might also be suitable alternatives for them. At the moment, the protection currently lasts for the duration of the maternity leave only, but as the slide points out, that is in the process of being changed. So it will be, the protected period will be from when the employee informs the employer that they're pregnant through to a period of 6 months after the end of maternity leave or adoption or shared parental leave. So it's going to extend the protected period and extend the class of employee who will be benefiting from that. At the moment, it's still going through the parliamentary system. It's had several readings in the House of Commons and it's due for its second reading in the House of Lords on the 3rd of March. So I wasn't able to find a sort of predicted date when it's coming into force, but I guess we could look at sometime during the summer potentially. Looking at the next slide. So looking at managing the risk around maternity and family leave, particularly looking at the questions of people on maternity leave. Consider staff who are absent and plan how you'll communicate with them. Carefully assess what is suitable alternative employment and allocate protected staff to vacant roles in accordance with their rights. Now, what is suitable alternative employment in this case? Well, it's where the work to be done is both suitable and appropriate for the employee on maternity leave to do in all the circumstances, and the capacity in place in which she is employed and the other terms and conditions of her employment are not substantially less favourable to her than if she continued to be employed in her old job. If any vacancies arise that are not suitable alternative employment, be sure you can justify your position in case of dispute. I think that makes sense. If necessary, consult whether a vacancy is suitable alternative employment. And that's really about heading off any sort of dispute at an early stage, if at all possible. Moving on to the next slide. So the final topic I'm covering is age discrimination. And there are lots of reported cases of employees challenging redundancy on the grounds of age discrimination. For example, if an employer has used last in, first out, or LIFO in their selection criteria, or experience as another criteria, or potentially the cost of redundancy as a criteria. There's also been a number of cases where comments from managers have been held to taint selection processes. So having a quick look before the session, I saw that some managers have been recorded as or evidence been given. They'd said that there was a need for new blood or the need for older employees to make way for younger members of staff. And those comments tainted the process. I guess the employees were able to demonstrate that there was an element of predetermination and discrimination in the process as a result of those comments being made. This slide's going to look in a little more depth at last in, first out, or LIFO. So just before we get into that, it's important to remember that with both direct and indirect age discrimination, the employer can justify its actions if it can show that it was a proportionate means of achieving a legitimate aim. So last in, first out, question mark. I think the general principle is that if you use last in, first out as the only criteria that you're applying in selecting individuals, that's going to be indirectly age discriminatory, and it's not going to be possible for you to justify that in, I would say, nearly all of the cases. However, if you use last in, first out as part of a selection matrix, a balanced selection matrix, then whilst it will have an indirectly discriminatory effect, there are several cases which demonstrate that you as an employer will be able to demonstrate that that was a proportionate means of achieving a legitimate aim. So looking at the Rolls-Royce case as one of the key illustrations of that. So Rolls-Royce used last in, first out as part of a selection matrix. And as I say, whilst that was considered to be indirect age discrimination, it was justified in the eyes of the Employment Appeal Tribunal. And Rolls-Royce were able to point to two legitimate aims. First, the stability of the workforce during a redundancy exercise. And second, the rewarding of loyalty or long service. And the tribunal accepts, it's widely accepted, those are legitimate aims, and it found that Rolls-Royce had acted in a proportionate way, given that the LIFO criteria sat within a much wider matrix of selection criteria as used. One of the other points in that case, which I think is helpful to note, is that Rolls-Royce had also in collective consultation addressed this issue up front. They were able to demonstrate that younger members of the workforce had bought into it to a certain extent, and the redundancy criteria had been agreed at a collective level. So looking at the final bullet point on this slide is around enhanced redundancy pay based on length of service. And the general position here is that the Equality Act has a specific exemption for enhanced redundancy schemes, which improve on the statutory scheme. Because if you think about it, statutory redundancy is a sort of age discriminatory calculation because it's based on age, importantly, and length of service. And there's an exemption for that, clearly. And if you enhance the statutory scheme, there's an Equality Act protection for that, but they must only be enhanced in certain ways. So you can remove the cap on a week's pay, you can increase the multiplier allowed for each year of employment, or you can increase the statutory amount, the final statutory amount, by a consistent multiplier. It's important to note that if you're using the statutory exemption for enhancing the statutory redundancy payment scheme, that you need to operate within the same age bands as the statutory scheme. So what if your enhanced redundancy scheme doesn't fall into that category? So it doesn't fall into one of the permitted ways of enhancing the statutory scheme. And I think there'll be quite a few schemes like that. For example, schemes that don't use the same age bands, or schemes that have preferential access to early retirement and things like that. So in those cases, if an employee alleges that the enhanced payments are discriminatory on the grounds of age, you'll then be looking at a justification argument. So is it a proportionate means of achieving a legitimate aim? And each case will be looked at on their own particular facts, which may involve those legitimate aims which Rolls-Royce pointed to: stability in the workforce and rewarding loyalty. So moving on to the last of the age discrimination slides. So this summarizes some of the points I've already made. So if you're using length of service as selection criteria, balance this against other criteria and consider objective justification. And in respect of enhanced redundancy pay, mirror the statutory scheme with some permitted exemptions, and they're listed there helpfully. Or alternatively, if your scheme falls outside of that regime, think about the basis on which that can be justified as a legitimate aim and a proportionate means of achieving that aim. Okay, so that's the end of our slides for today. And I think now Bob and I were going to move into answering some of the questions which may have come in. So if I have a look in the Q&A box. So the first question is, can you please talk about how we approach redundancy pools when there are colleagues on fixed-term contracts, e.g. a fixed-term contract is coming to its natural end and work is ceasing? Do we need to apply a redundancy pool against permanent staff? Bob, do you want to look at that one?
I think the answer to that is maybe. When a fixed-term contract expires, it's important not to conflate the fact that it is coming to an end by reason of the expiry with the reason for the dismissal. You have to identify the potentially fair reason for dismissal that you're relying on. And a lot of the time, that will be redundancy, because the work for which they are employed on the fixed term has ceased or diminished. And if the employee has more than 2 years service, unfair dismissal considerations will apply. And therefore, you will have to consider suitable alternative employment and explore it with them. And there may be some circumstances in which it would be appropriate to consider pooling them with other employees, indeed permanent employees. But that will very much depend on the specific circumstances. So there's an enormous range of possibilities there, but it's certainly one of the potential situations that could apply when a fixed term contract expires. I think that's probably about as much as we can say here, but if you want to talk in more detail, by all means do get in touch. The next question is, what potential claim could an employee bring if they were bumped to mitigate the redundancy of another member of staff? Michael, I think all of the questions are about Paul's suitable alternative employment or bumping. So,
all right, well, I'll chip in as and when I feel the need.
Okay, so what potential claim could an employee bring if they were bumped to mitigate the redundancy of another member of staff? Well, yes, they could challenge the fairness of that decision, and given the discretionary nature of a bumping situation, in some, maybe even many circumstances, it might be easier for an employee who's lost their role, even though there's no reduction or cessation in the need for the work of the type they perform, to challenge the reasonableness of a dismissal on a bumping ground than it would be for someone who has not been considered for bumping. So yeah, there's a fairly obvious unfair dismissal risk there, but again, it's down to the employer's discretion. So they'd have to show that you'd exercise that unreasonably in order to succeed in an unfair dismissal claim. The next question is, what part do personal circumstances play when assessing the suitability of a role? For example, a part-time employee with childcare responsibilities being offered a full-time role that fits within their skill set, or a role requiring further travel where they currently walk to work, can they decline it on the basis it isn't suitable? Okay, so when we're talking about employees receiving statutory redundancy pay because they have reasonably refused suitable alternative employment, or where a role offered wasn't unsuitable, you've got a two-stage test. Assessment of suitability is an objective test that shouldn't take into account the employee's subjective circumstances, but to a limited degree, external personal circumstances can be a factor. But certainly things like full-time versus part-time is a difference in hours, so that's going to be a material factor. You also need to consider the risk of indirect sex discrimination arguments when offering part-time employees full-time roles, and they need to objectively justify that approach because it is accepted that more women than men do part-time roles in the workforce, and so there's the objective justification argument in that particular circumstance. Questions about the reasonableness or otherwise of a refusal of alternative employment are more involved in the employee's personal circumstances. So if they have a particular reason that applies to them that makes a rejection reasonable, even though the role is suitable under the statutory regime for redundancy pay, that would still mean they're entitled to the payment because their subjective circumstances allow them to act reasonably. So that's a fairly complicated answer. It is a relatively tricky area of law, and you've got two things to factor in, both unfair dismissal considerations and statutory redundancy pay regimes on reasonable rejection of suitable alternative employment. So there's a lot to pack in there. Do you have to be given the notice of redundancy to kickstart the trial period? Yes, Section 138 is explicit that notice of termination has to be given in order for a trial period, a statutory trial period, to apply. So at least that's a straightforward answer. How are we doing for time? Okay, doing all right. So the next question is, in terms of exploring alternative employment, we provide access to redeployment for a 6-month period prior to the expected end date, sometimes shorter, but always no less than 3 months. We write to confirm eligibility and provide them with a mechanism to apply for posts as a preferred redeployment candidate. Is this sufficient to evidence our responsibilities in searching for suitable employment, when in reality the individual is the one searching? We have multiple vacancies every day, let alone every month. Thanks. Michael, do you want to take that one? I mean,
yeah. I mean, I think it is fairly common practice, isn't it, to provide the opportunity for individuals to apply for roles. and to search for roles. And it sounds like you're doing a significant amount there. So I would say that, is this sufficient to evidence your responsibility for searching for alternative employment? It would certainly look like it, yes, as long as you facilitated access to those job boards and everything else, then it certainly would appear you're fulfilling that obligation. Obviously, looking at the discrimination aspects potentially, if an individual's particular disability makes accessing those things difficult, then you might have to think about reasonable adjustments about that process and about how they can have access to the same level of information as others. And employees who may be absent on maternity leave or through illness, you need to make sure they also have the requisite access and knowledge of those facilities. So I think that's what I was going to say on that one, Bob. I don't know if you've got anything else.
No, I agree. I mean, as you say, particularly amongst larger institutional employers that we act for, that kind of open redeployment pool and access to online vacancies across the entire organization is a common approach. The next question is a repeat of a previous one, but with a bit extra. So does notice have to be given to trigger the statutory trial period requirement? Yes. And if so, how does a stat trial interact with Reg 10 as trial triggered by a change in TNC? So would there be a scenario where Reg 10 and stat trial interact? Okay, so that's a reference to the priority given to maternity leave, to people on maternity leave under Regulation 10 of the maternity regulations. So would there be a scenario where that priority and the statutory trial period interact? Michael, is that one for you on the maternity side?
Yeah, I mean, I think some of these questions can always be complicated in practice, but I think that if an individual is entitled to be offered the role under Regulation 10, so they have preferential access to it, it's a suitable alternative employment, and they accept that, then they'll be entitled to a trial period when they return from maternity leave, just as anyone else would. And I think that probably covers that, doesn't it?
Yeah, I think there's an interesting question, and I'm not sure it's one I can answer off the top of my head, as to whether the right to alternative, but the preemption of alternative employment supersedes the employer's ability to assess suitability in a trial period. I don't think it does, because the right to preemption is the right to be offered suitable alternative employment ahead of anyone else. And the purpose of a trial period is to assess suitability. So it's still open for both parties to be assessing suitable, whether it is indeed suitable alternative employment. Because if it's not suitable alternative employment, the right to preemption doesn't apply. So I think that's how they interact on both sides.
Yeah.
The next question is, if we reduce a sessional teacher's hours by 40% or less, do we still need to pay redundancy? Is this a redundancy situation?
Well, I think that will depend on all the facts in the round, but I'd say that a significant reduction in hours, there is certainly a risk that it might well be redundancy, because there's it will be a business reorganization potentially, I suppose, but it will be an analysis of whether work of a particular kind, I think, had reduced. And there is some difficulty sometimes in assessing whether reduction in hours is of itself reduction in work of a particular kind.
And it might be in some circumstances that you have a redundancy situation due to a reduction in hours, but that the reduced role is alternative employment. It might not be suitable alternative employment. So it can be offered to the employee with them having a right to reject it and take redundancy. but if they accept it, then they have accepted alternative employment and therefore aren't entitled to a redundancy payment. That
Such
won't
a
happen all the
significant-
times.
No.
Yeah, it's very fact specific, but that could be one of the outcomes.
Yeah, and it's a significant drop in hours there, isn't
Yes,
it?
it is. Yeah.
Okay, so the next one is a maternity query. We have a redeployment policy whereby individuals have preferential treatment for alternative employment. Does this mean if on maternity, this would supersede others in the redeployment pool? Okay, so I'm just taking that in a minute. Well,
I'm not quite sure what that means.
I'm not quite sure, but I think the statutory protections for employees on maternity leave will take priority over any internal policies you may have. The internal policy, a lot of internal policies for large employers will have preferential access for people at risk of redundancy to apply for vacancies. But that, I think, would be that the statutory protections will, of course, be the primary protections around that, and nothing in a policy could get around that.
Yeah. We've got quite a few further questions, but I think we're about to run out of time.
We are.
So sorry for those of you who have asked the question we've not managed to answer. If you've not asked it anonymously, we will try to contact you directly with a short view.
And I was just going to go on to the two final slides, and it's a bit of a plug, really. So if you're line managers, if you want to upskill them in employment law and HR issues, which I'm sure we all want to do, then there is a series of 9 short courses which are provided by VWV to help that be achieved. Excellent value for money, obviously, and an excellent resource. So if we move on to the final slide, if you're interested in looking into that and having contact, then please vote, and someone will be in touch with you to provide more information about how that resource works. Otherwise, I think it's just left for me and Bob to say thank you very much for attending. I hope it was useful. Thank you very much for your questions. Always challenging and enjoyable to respond to, and look forward to seeing you again at the next webinar that we're involved in.
Thanks all. Goodbye.